very deeply of that. Because
So far as item 502 is concerned,
yes.
my lord, the contours is the freedom of speech. And what are the limitations? My lord, your lordships would recall, I will not take names, but one former honorable chief minister made certain remarks with regard to some, my lord, the unfortunate incident of rape having been committed. My lord, according to me, by subsequent judgments, my lord, this law is fairly well settled. But my lord, we are prepared fully. If your lordships would like to be assisted, what are the contours of freedom of speech?
No, but I saw from the records the concerned person has apologized and his apologies already accepted. So whether this has also become academic,
Lord,
because he has apologized and apologies accepted here.
Shall I make a very short response to your lordship's query, my lord? I am in I am the next item tagged along with this. My respectful submission to your lordship's query would be this. So this particular case arose from certain statements made by the then minister in Kerala, which were containing disparaging remarks against women, certain employees, laborers, etc., etc. Then the question arose: what is the limit of freedom for the public functionaries? This is an issue which is being repeated again and again. And in fact, in this matter, another bench heard it to some extent, and we even submitted written submissions. That bench cannot be reconstituted, because their lordships, respected lordships, got retired. Now, your lordship may have to address certain fundamental issues like limit of freedom to the constitutional functionaries, including the ministers, the MPs, the MLAs, etc., etc. This is a recurring issue happening here or there, very frequently being repeated. Therefore, I would say, it may not be an academic issue. Your lordship may fix a date. We have, in fact, not made a thorough research on this as to whether the freedom of a minister is akin to a freedom of an ordinary citizen, and how that will affect the constitutional values, if not constitutional rights. But these are the matters which will have to be deliberated. We conducted an extensive research on this. It may not be limited to that UP chief minister's issue alone. Even thereafter, even the central ministers or state government ministers will often repeat this. Therefore, my lord, this is an issue of vital importance. And that is the reason for referring this. And the reason for reference still remains relevant.
I appear as an amicus in the matter, and I agree with the learned SG that these are the matters which have always developed case by case, your lordships. So in this particular case, the issue was fair investigation, and the person has already apologized. And we filed our written submissions, and this is our submission that these issues have already been decided by your lordships in various judgments. The various rights, fundamental rights, they have been balanced inter se. So your lordships may take it up, and I think we can show.
So is it the right of only ministers or all other lawmakers? Because whatever statements they make in public, that may have a bearing, because ultimately they are the lawmakers.
Correct.
Yes.
Public functionaries, let us
That is public functionaries, a very broad category, very
Yes.
general category.
No,
Not
even
just ministers.
MLAs and MPs are also public functionaries.
Yes.
So lordships, this particular aspect is fair investigation.
Here, incidentally, one of the chief ministers.
Lord, some of the persons, my lord, may or may not be MLA or MP, but still as a leader, he may be in the capacity of a public figure.
He may not be
A party president or something. But the
is-
point is this, my lord, whether Article 19(1)(a) and the exception thereto would be differently applied to public functionaries while they are speaking to a larger audience or not. That is the question, which is a live question. Thereafter, my lord, after framing of this question, this is a matter of 2016. The contours are, my lord, defined, as the learned amicus rightly says, on case-to-case basis. And it would essentially be, my lord, it would not be possible for your lordships to lay down straitjacket line of distinction that you can cross this line and not this line. It would be an individual case where law will have to be invoked. Somebody makes a statement which is not strictly in accordance with 19(1)(a), but transgressing his right, freedom of speech. But the question is important, my lord. My learned friend, my lord, has
Your colleague has done an exhaustive research.
Yes, my lord, we have done the research.
So far as
See,
Available in public domain.
see, right to freedom of speech and expression is essentially against the state. And 19(2) are the reasonable restrictions. Now, if a particular person has made a speech which is not liked by somebody else, then that somebody else can always take action. Now, when 19(2) is already there and 19(1)(a) is there, there can't be some other restrictions over and above 19(2) which can be imposed because the Constitution doesn't recognize that. Therefore, the question is, if anybody is aggrieved by somebody's speech, what action can be taken?
Your ladyship, my lord, your ladyship is absolutely right. My lord, in fact, our written submission is in this line. Or may not be because of 19(2), a further restriction, that to a judicial restriction, may be apparently impermissible. But at the same time, when there are horizontal right violation, what else could be done? In fact, my lord, in our written submissions, we have made a suggestion how a constitutional restriction can be made without hampering the constitutional values. This is the purpose. We have suggested what a kind of promulgation of self-regulation for public functionaries, borrowing, my lord, certain models from other jurisdictions. We have placed it right from England and from Australia, how the public functionary should behave publicly. That is very important. For example, but in the Kerala minister's
That
case,
is one aspect, please listen to us, but it requires a factual background, right?
that's right.
You can't decide a question in thin air. You need certain facts. On the basis of the facts only you have to decide.
Each one.
Now, we don't know what the facts are here. Can you lay some general guidelines, without factual background?
so far as Kerala case is
I may
concerned,
answer that. In
is
fact,
not
Lord, as far as Kerala case is concerned,
Okay.
Lord, this arises
so
from
far
a
as
matter
UP case is
from Kerala
concerned,
High Court.
Just 1 second. What is that?
so far as UP case is concerned, my lord, there has been an investigation. Subsequently, the chief minister opposed. So far as Kerala case is concerned, once when he was the minister, he made a remarks like this. Then we moved the High Court. High Court said nothing doing. Thereafter, we were granted liberty to come here, and we were granted liberty to get impleaded here.
Who are you? Who are you?
I am for an intervener in Kaushal Kishore's matter. Therefore, that fact remains. Thereafter, what happened is he still goes on making such kind of remarks. Therefore, my lord, this has to happen. So, at least so far as Kerala case is concerned, there has not been an investigation. No investigation happened. No report came.
Does he?
No apologies.
Please listen.
Yes.
Does he deny that allegations made, or does he admit and he says
He admitted, and thereafter.
he asserts it?
Yes,
He has
he
a right.
asserts it.
He
And
admits that
one
he's-
such one of his remarks ultimately resulted in some other case being reinvestigated, further investigated, and a final report being preferred. He made a submission.
the facts
This case on 12th November.
12th. Yes,
We have hardly 2 weeks.
yes.
we have placed
I must say, my lord, as an officer of the court, the
facts will
threshold,
be discernible.
only a minute.
1 second. Facts will be discernible from the memorandum itself. Lord, it is stated from
Yes,
page
sir.
F to K.
1 minute,
Facts
Mr.
are-
Consul, please,
We will
1
have
minute.
it. Oh, no, we can have it only
set a difference.
No, 15 November.
I'm sorry.
No.
Grateful.
List it on 15th, right?
Yes, my lord, I must say, my lord, the threshold of my right as a freedom of expression, speech and expression, if I am in a public leader capacity, would be much higher. There is no doubt about it. A layman can say whatever he wants, and a leader may still not be able to say whatever he wants. But to judicially define that demarcating line would not be, my lord, a
It will be
easy
difficult.
exercise.
And it has always to be related to the factual situation.
Factual situation. It will have to be subject.
Actual situation, my lord, in Kerala case, my lord, has been indicated right to the judgment and even in the SLP, my lord, 3 instances. And after the instances, not only that he didn't deny it, he even reiterated it. He even justified it. My lord, that is a big problem. And similar situations occur elsewhere also. Therefore, this requires a deliberation.
Worships, in this particular case, the issue is fair investigation and balancing the right under Article 21, which is a fair investigation, and right to speech. So, your lordships, this issue has already been decided. We'll show it to your lordships, and your lordships will then examine it and pay the time.
We will have it on 15th,
Yes.
right?
Yes.
List on 15th.
Yes. My lord, may I make one submission? 107414, I am the intervener. My lord, may ask, my name is not being shown, therefore I will have.
Show his name also.
Yes.